talking about confidentiality, non-compete, non-solicit, and so these clauses in fact in agreements. And then we are going to get into actually opening and drafting a non-disclosure agreement. We're going to open up the agreement and we're going to discuss a non-disclosure agreement. Now, non-disclosure agreements are something which are very common in the sense that you can get NDA drafting assignments very, very commonly. Like, this is kind of one of the first agreements that people enter into before they are getting into investment, before they are even getting an audit, internal audit sort of thing conducted, or any kind of due diligence being conducted. So these agreements are very common. So if you learn how to draft these agreements, I'm looking to have a session with you guys tomorrow on how to develop an Upwork profile. And you can straight away search for or look for, like you can add this to your profile in addition to the other things that you may be learning or maybe having in your background. And if you add non-disclosure agreements as something that you can draft to your profile, there will be matching assignments that you get in order to take up. So we're going to be talking about that or developing Upwork profiles tomorrow. But because of this, background that I just gave you, I would like you guys to really participate and understand how the clauses are drafted and particularly how NDAs are drafted, so that you can take up paid assignments for this. Okay. So let me, Nishwita, I'll hand it over to you. Do you want me to share the class structure?
Yes, please.
Yeah. Okay.
Okay, good evening, everyone. So today we are going to discuss on confidentiality, non-compete, and non-solicit clauses. So these three are considered to be the survival clauses in an agreement. So I will explain that in detail a bit later. So first of all, let's understand what is confidentiality. And this is a term which is very vaguely used even in our day-to-day conversations, right? We say that this is secret. Please don't reveal it to anyone. I'm just sharing it with you. Be rest assured that I will not share it. So these are something that we keep telling even in our day-to-day conversations. So technically what happens whenever there is any sort of a commercial transaction is being entered between any two parties, it is important that both the parties have mutual trust on each other. So yes, I can say, okay, the other person is renowned in the market. He may not share. That's a trust that I have within, but you need something even documented. So that is where this confidentiality clause plays a very vital role. So first thing when we see of the confidentiality, can you open those internal notes as well, Kumar? For each which I've added. So you have to scroll down a bit. So confidentiality agreement is something which is being executed under two different scenarios. Firstly, even before execution of the master agreement, if there is a mere negotiation that is still happening, nothing is concluded, but you want to give some very confidential data of your company to another person in the event of making an investment or conduct a due diligence, we execute an NDA. That's a non-disclosure agreement, an agreement which is executed even before drafting or before executing a commercial agreement. Another phase is confidentiality agreement. Maybe a clause in itself is included in the master agreement. So these are the two different situations when a confidentiality clause will take place. As I clearly called out, this is a survival clause. So let me explain what a survival clause. Whenever an agreement is being executed between two parties, parties decide that few clauses need to continue even after the termination of the agreement. So such clauses are known as survival clauses. So we identify confidentiality, non-compete, non-solicit as the survival clauses. Apart from that, if there is any obligations as well, which need to survive after the termination, like maybe a payment is still due, that is also a survival clause in an event when it is applicable. But by default, these three clauses become survival clauses. Next thing, why do we always say that a confidentiality should be maintained? Few things are completely governed under the transaction. When two parties are entering into a contract, it is based on the mutual trust. They want to maintain that confidentiality. At times, it is even regulated under the law. If you see in India, we have a SEBI insider trading regulations. I'll not get into much of details, but it says that whenever a listed company is entering into any sort of a transaction, when there is an investment or purchase of shares, when it's still in the preliminary stage, they avoid the insider trading. So at that point in time, you ensure there is a confidentiality clause between two major investors who would come just in a preliminary. The first person who need to go is the SEBI needs to have this information, your stock exchange needs to have this information so that there is no very high fluctuation in the share price. The interest of the common man is not infringed. So that is the intent where under the law also in few circumstances it has been governed. So very minimalistic if you have to understand confidentiality is something in every commercial transaction the parties would like to protect. Next is non-compete clause. So by the word itself, non-compete is where you don't want to have a competition. So a question that comes to each one of our mind, right? How can I stop a person from conducting a business? How can I stop another person to carry on his own profession? Because under our constitution also, we have that right where every person has a right to conduct a occupation or a profession of their own choice as long as it is legal. So it is my fundamental right. What can I do? Going further, even though Section 27 of the Indian Contract Act very clearly says that I cannot have a complete restriction on a person to carry on any sort of a legal profession or a occupation. When you see the Constitution is giving a right to a person to conduct whatever he wants, you see even the Indian Contract Act is imposing a bar, then what is this whole non-compete clause? See, there are many occasions where you are a business person, you would have sold your business to an X person. Okay. So now the X person is completely dependent on your goodwill, the importance that you have gained in that particular market, the products, everything. So don't you think even that X person's interest has to be protected? At that point in time, a non-compete clause will be included in such transactions. However, as a lawyer, something when you draft, you need to always keep in mind the non-compete clause has to be reasonable in nature. So the definition of reasonableness is not given under any law. It is something which you need to assess logically as well as by the judicial precedent. So maybe you can say that now my business was in Delhi. I sold my boutique, which is there in Delhi, to one of person for a very good amount. I sold and came. So my non-compete clause can say that Nishwita cannot start a boutique in Delhi. Maybe you can have that whole geography, Delhi itself you can do. Or if there is one particular lane, like MG Road, you cannot start a business, again, a boutique business in MG Road for a period of next 2 to 3 years, whatever you can decide. So it is reasonable where I can do the business apart from Delhi in any other geography, I can do it. It even says that after 3 years, I can start the similar business in the same lane. That is still fine. So there is a reasonable restriction that has been imposed on the other person. The intent is just to protect the interest of the purchaser. Okay, next is non-compete clause. Sorry, non-solicit clause. What does solicitation mean? Solicitation means you're, in a very HR words or in something which you say, you're poaching a person. You are just taking a person who is in someone other's roles. Okay, solicitation is most of the instances what happen when a person is working in the organization. Once he steps out from that organization, there is always a threat. He will know the entire confidential data of the company. He may even start a competing business because he is the founder of that company, and he may even start a competing business. Plus, if he takes all the market head, the legal head of the company, if he gives them an additional payment, say 100% increment, and he takes all the top people from the organization and start his own business, then the other person will be adversely affected. So non-solicitation should again be governed under the principle of reasonableness, where they say that the clause should be reasonable, where you restrict a person from soliciting your employees, your marketing agents, or you can even clearly call out who are the people, like your vendors or your suppliers. All these people cannot be solicited for a prescribed time frame. So these three are the survival clauses. Let me even give you an example. In Apple, when the founders gave their shares, especially this happens at very renowned business transactions. Even in Karnataka, I don't know how many of you know Kannada newspaper. There's a newspaper called Vijay Karnataka, which was later purchased by Times of India. It was a Kannada vernacular language paper where they had a very clear non-compete and a non-solicit clause for a period of 5 years, where they said that Vijay Karnataka, being a Kannada vernacular paper, the person who sold it, Vijay Sankeshwar, should not start the same business. That is a print media business for the period of next 5 years. So for 5 years, he didn't do it. But on the 6th year, he started a similar, again, Kannada paper. But however, he was bound by this non-compete and the non-solicit clause. Okay. So this always happens. Even in case of Apple, when founders were there, they were not permitted to start a similar set of business. So moving on. We'll open for questions now, or I'll just finish off the examples, then we'll take it up, Komal.
Yeah, no, I had a couple of additions here.
Okay.
Just that, a survival clause as such can be a separate. So it will just say that 1, 2, 3 clauses will survive the termination of the agreement. Okay. But these 3 clauses are themselves, they are not survival clauses, but they will survive after the termination of the agreement for a particular period of time. So you will put that as a beginning. This is my understanding of so survival clause will that will only be a statement that 1, 2, 3, 4, 5 parts of this agreement will survive the termination of the agreement. That's all that it will say. And then these clauses will begin with stating that for a period, for the duration of this agreement and X number of years thereafter, that should be this is how I have seen the agreements. It can be different how people interpret or write it, but this is the way I have seen the agreement. And non-compete and non-solicit, the other things are to say the logic from the side of the person on whom these clauses are imposed, right? So in non-compete, the situation that happens is that someone has done some particular kind of work for a large part of his life. Now, if you take the right away from him to do that work after he is left the employment or after he is done with the transaction, his daily living can become a question, because that is the skill that they have associated with for the whole life. So that is the reason why there is this insistence that it should be reasonable, because you can't impose things like that. Obviously, your clause in restraint of trade is relevant, but the logic is this. Logic even behind restraining trade is this: is that someone has done something for their entire life. You suddenly say that you can't, like after leaving this employment, you can't engage in this. What else is he going to do? Learn a completely new skill, and how will he survive? So that's one reasonable side or point of view from the person on whom this clause is imposed. And non-solicit also similarly, like you may not solicit, but there is no bar to someone themselves leaving it. Like there should be no evidence that you have provoked someone to leave, but people are free otherwise to give a termination notice for their employment and leave and join someone else. So when there is an evidence to that effect that there wasn't any kind of provocation or solicitation and someone left on their own and joined, then that doesn't become a breach of a non-solicit clause. We'll come to questions on this, but Nishwita, you can continue with the examples. We'll come to questions after we have completed this section. Otherwise, the class goes into a completely different direction. So let's reserve a specific time for questions after each section break. It will be a better way to deal with the topic. Yes, Nishwita, please continue.
Yeah, as I can explain you further, I'm sure most of your doubts will be clarified. So let's see what are the examples. So next is confidentiality clauses. I need the internal note. Confidentiality clauses, as we said, it is very important in any sort of a commercial transaction. So now let's take the example of the employment agreement. Most of you, once you join any sort of an organization, you will have the employment agreement, or whatever you call it, as an appointment letter. So what happens? First thing, in an employment agreement, You need to scroll down a bit so that they can see. Okay, so very clearly we are going to say employment agreement maintain confidentiality during the term and dash number of years. You can decide maybe 12 months or 2 years, whatever it is. So confidentiality per se is during the existence of the agreement, as well as once you quit the organization, you have to maintain that confidentiality. Now, when you say that a non-compete clause, the second line is I'm talking about the same employment agreement so that it helps you how all these three clauses are going to come. Non-compete agreement, you're going to say that you're not going to join the competitor company or you're not going to start your own business. Non-solicit, you're going to say that you're not going to solicit any other employees of the organization or vendors, marketing agent. Let me give you, it's not that someone in the JL1 level or a very fresher is going to solicit or join a competitor company. How it works is usually if a managing director of a company who has complete strategic information of the organization, he knows end-to-end business details. What is the forecast that the company has for next 1 year? Because he will have the complete visibility. He may decide to quit on his own, or there may be even a process of termination where an MD of the company may have to leave. That time, this clauses plays a very important role because he is having a very high level information of the company, where we are going to say that you are going to maintain the confidentiality during the period of, so during the term of the agreement, plus for a period of 12 months or 2 years, you're not. Second thing, you're not going to join the competitor. For example, if you say two major competitors in the IT setup, like Infosys and TCS, both are very, very closely competitors in the market. Both are in the IT sectors. You can say, you can even list out that, saying that once you put this organization, these are the list of competitors, like Amazon is my competitor or TCS is my competitor. Just give the list of 4, 5, and you're not going to join them for next, so maybe a year, you're not supposed to join because he has a visibility for the next 1 year of forecast. Next is he is not going to solicit because now from Amazon, he is going to join the Flipkart. Both are in the e-commerce platform. He may be in a position to solicit the Amazon marketing head, Amazon person who's a legal head. So if we start soliciting and using that for Flipkart, then the business of Amazon will be adversely impacted. Then you impose such clauses. So another concept is just for your visibility purpose, and most of the organizations, what they do is there is a concept called as garden leave. Garden leave means an MD decides to quit the organization. He will have to serve a certain period of notice period, like for 3 months or 6 months. Usually for these high profile people, the notice period is slightly longer duration. At least they keep it for 3+ months. So if you keep 6 months, you give him salary, but you will not involve him in any sort of a business meetings, nothing. Like entire his complete access to the system will be withdrawn. He will not have any access to the company details for that notice period of 3 or 4 months, whatever. Intent is during that period, the company can think of some other strategic decision, because if he breaches the confidentiality or if he starts his own business, that's always a threat. So they give this garden leave, all the benefits, all the social security benefits, salary, all the things will be given to him. But during that notice period, he is not going to work. Or at times, what they do is for next period of 1 year also will pay you the salary, but don't join any other company. Even such negotiations will be done. Let me give you another example. Okay, like just imagine a chef in the restaurant who is renowned, or I mean, all of you know that if it is some five-star hotel, there is some sort of a signature dish where every customer will just go and enjoy that meal. That's because of that particular dish that has been prepared by a person. If a chef of the ITC who's in Taj and he just quits and he goes to Winsamana and he knows the entire recipe, if he starts preparing the same thing, automatically the customer will move from Taj to Winsamana. So that time also a similar clauses will be imposed where you say that you are not going to share the signature dish recipe to any of the other competitors. See, in this case, he is a chef. He knows only one particular skill, that is cooking. Apart from that, he doesn't know anything. So again, you can either have the garden leave concept for a period of time, or you can even say that you're not going to join the competitor in the same location at least. Like if you were working in Bangalore, you're not going to join again Winsamana, Bangalore only. You can join Delhi, Kolkata, elsewhere, but not in Bangalore. Such reasonable restrictions can be imposed. So I have explained you in employment agreement, how do we do the confidentiality, non-solicit, and non-compete. And next is, let's look at the other example, like a business sale agreement. I already gave you one example where uh, the vernacular newspaper, Kannada newspaper, was sold by the founder to Times of India. That's one. Second thing is where he was not permitted to start an entity for a period of 5 years, but after 5 years, he could start. So that was reasonable. The intent here is now Times of India during that period of 5 years, they would have gained that market. They would have won the entire customer relationship. So that's very much important. So in business sale transactions, also what happens if he's especially a founder of that particular entity, they say that you are not supposed to start a similar business in the same geography. Because most of the time, if you see today, if you're going to talk about Apple, the first thing that comes more than phone, the person who found, because you closely associate with that person's name. So the goodwill is also driven with that particular individual. So if the same person is going to start the restaurant, start the same automobile, or start the same technology driven, people will again go as per that person. They will not go for it. I'll give you another example which happened in Bangalore as well. After that, there was some out of court settlement. I don't know if you're in Bangalore, you can closely associate. There was a chain of restaurants called, like MTR, also same thing happened. There was a chain of restaurant called MTR, which is very famous in Bangalore, especially in South India. It's very famous. And the founder of MTR sold his business to, first of all, initially it was basically a merger where 51% was taken by the foreign entity, rest 49 was with the MTR. Later in the JV transaction, they started selling a portion of it, and finally 100% was taken by the foreign entity. But till date, people think only of MTR. It's not, they, most of them didn't know that there is a sale transaction which happened. It went to a foreign entity. People just started connecting with that Maya's family because it was a family owned restaurant and people were very much associated. Now, when the person came out and stepped out and he started his own Maya's restaurant, 80% of the customers who were going to MTR started deviating to Maya's because it was the same dish, same taste, it is the same person. People couldn't differentiate between which is MTR and which is Maya's. They felt it's a two different chain of restaurants started by the same person. So then there was a dispute. Then there was an out of court settlement and said that at least when you're doing it for next 2 years, you're not going to start any sort of business. Now the founder came back with a Pakashala restaurant. So that's how all these things work. So you need to be very thoughtful when you draft this non-compete and non-solicit clauses. Solicitation is basically when you are soliciting the employees, marketing head people. Competing is when your competing business has been started by you or when you join the competitor company. Let's see another example, like a distribution agreement. What happens in distribution agreement is we as a person enter into a distribution agreement with X person to supply goods to us, right? It's a supplier driven and he's going to supply the goods. And this is something which is so important. Maybe it's a particular fabric, like you are someone who is of apparels based, you have only Khadi. Khadi is your primary manufacturer. Let's take it like that. And your distributor, whoever is giving you the supplier, he is someone who is supplying Khadi to you. And you are set up your business in Bangalore. Everyone knows your brand, and that specific quality of Khadi is given only by that supplier. Now, what happens? You will enter into a distribution agreement, an exclusive agreement, and very clearly you're going to call out to him saying that you are not going to give this quality of Khadi to any of my competitors because this is my signature fabric, which customers need to come to me and only purchase. They cannot go and purchase from my competitor. So you can have this exclusive distribution agreement imposing a restriction on him that you are not going to sell this fabric. And the other thing also, what happens in such situations, you make this non-compete, non-solicit survival because he would be exposed to your marketing strategy. How are you going to use this Khadi in the time of manufacture? What is that blend that you're going to do? So he will have further additional details as well. So you can even go ahead and impose this non-solicit, non-compete clause that even after the termination of this distribution agreement, at least for a specified duration of time, you're not going to give the same Khadi material to the competitor in the same region so that your business is being protected. Now, like a consulting agreement, okay, not that all the consulting agreements will have this non-compete stuff, but you should always be very mindful of the professional ethics. Like, for example, as a consultant, I'm a lawyer, I'm a consultant for Prestige. Now, I cannot, at the same point in time, give the legal opinion for the same subject matter to RMZ. However, I can give it to a different subject matter to RMZ, who is my competitor. That is still fine. But our professional ethics is also something which needs to be governed, especially in the items where R&D happens and a consultant is appointed. R&D is something, a huge investment by the company. Like in a container company where I'm working in shipping, we invest a lot in how a cruise need to be built, how the containers need to be there, how the packing, how we need to stop in the port. All these things involves a huge investment, and a company invests almost 30% of its entire amount only in R&D just to improvise the cruise so that you're up in the market. Like your storage space needs to increase. You can't go with a very old tradition. And can you have a two-level of storage? Is that possible? How to place those goods, like perishable goods need to be in the front. If it is durable, how are you going to place it? Do you need any sort of a refrigeration in the shipping? All these things are a lot of R&D that has been involved. Now, a person does this R&D to me, he gives me the entire plan structure, and as a company, I go ahead and start making investment in building the cruise, maybe through some other vendor. Now, this person who has done an R&D has the complete details of my cruise, which is my confidential data. Second thing, he'll have ideas of what my shipping company is going to do for the next 1 year. How will it planned? How am I going to project my ships to the customers? So these are very minute details which he will be exposed to because he needed it while he has to do his R&D. It was inevitable that I had to share with him. So then I impose a clause, your R&D is complete, but even after that, these R&D documents or details that you have is purely confidential and you're not going to share with any of my competitor. And in most of the strategic decisions, we even say that at least for a period of next 6 to 8 months, you're not going to do with the same R&D of building the cruise or shipping any of these things for our competitor. For that reason, the fee also for next 6 months, most of the time has been borne by us, because for us, giving that fees is less cost impactful compared to the confidential data that he has. Considering his livelihood, we would be done that, research and development. Okay, so these are 4 different examples that I've given you. Like this can be case to case basis. You will have to analyze it, how you need to take it up, but always be very mindful of the concept reasonableness, because if something is not reasonable, it can be completely struck down in the court of law. So think how you can make it very impactful, as well as the business needs to be up and running. Fine. So moving on.
Yeah, I think we can break for questions now, Ashwita. So
okay.
Questions, it preferable is people unmute themselves and ask.
I thought we'll do of the drafting, because I'm sure few of their questions would be completely resolved there. Once we do the drafting of confidentiality, non-compete, non-solicit, I'm sure few questions will be resolved. Then
unless the concept is clear, let
okay, fine,
ask
no problem.
Questions related to concept.
Sure.
As such.
Yeah. Excuse me, I have one doubt. I'm not clear about the part. How is the constitutionality of the barring from similar trade holds good in the eyes of law with reasonableness? Because I'm not sure how it is contradicting and still it is acceptable.
Yeah.
You're muted again.
Ma'am, you are on mute.
I'm sorry. So under section 27 of the Indian Contract Act, any restriction on conducting a profession or occupation, complete restriction is void. Now, I am not imposing a complete restriction. See, I gave you an instance of running a boutique, right? Like I was running a boutique in Delhi in MG Road. Now, this was well known. Someone purchased it from me. Now, my restriction is reasonable, where I'm saying in Delhi and in that MG Road, I am not going to run the business for a period of next 2 years. And in Delhi, I'm not going to run it for next 1 year. However, I didn't give an unreasonable restriction saying that you shouldn't run the boutique business at all, because that is my expertise. That is my skill. Apart from stitching.
Excuse me, this is where I got a doubt. Now, you are a resident of Delhi. Now you are restricted from running a boutique business in the entire Delhi for a period of 1 year and 2 years in that particular locality. Now, for that 1 year, you will not be able to earn your bread and butter if that's the only thing that you know.
Okay.
So how can this reasonableness, which might seem reasonable to you, might not seem reasonable to me?
Okay.
So when it goes to court, most of the times there are chances of it getting struck down, right? That's why I wanted to know how companies are successful in it, in implementing it.
Okay, so let me help you understand that. Now, I have taken this conscious decision when this agreement was drafted, saying that yes, in Delhi, I will not hold the business for next 1 year. I have decided this. Who is stopping me to just do it in-house, apart from Delhi location, to use a e-commerce like Amazon or Flipkart and do those sales in other regions? Who is stopping me? I can still be in my home, I can still earn, and I can sell the clothes. Second thing, if I have taken this decision of not conducting the business or running up the business in Delhi for 1 year, I would have other plans of relocating. Maybe it was my personal decision as well.
Yeah.
So that's how it will be looked by the court. When all the doors are shut, only then it becomes unreasonable.
Okay. Okay. Thank you.
Also, there is see, I agree that there are chances that it becomes very difficult for a court to determine whether it is reasonable or not, because from the way you pointed out, maybe there is a balance of convenience in favor of the person who is restrained from carrying out the trade. But in these cases, inevitably, where there is a competing business or competing stuff that is created, there is also an accompanying breach of confidentiality. Okay, now understand this. If you are out, like, how many of you have seen the movie Rocket Singh? Okay, in there, this kind of stuff, this is exactly what gets portrayed. Now, if I am with a business, and even if I am doing the same business, but I take an entirely different customer line, and I ensure that nothing of the business of the former person is actually getting impacted. I'm going to the ground, developing completely new customer base, not taking anything from the business model, not working in the same way as the former employer. All those things I'm not doing. Then it will be very difficult, for the court to say, because the business of the original person is not really getting impacted because of that. However, where it is accompanied by a breach of confidentiality, and that usually is the case, because when people come out of that existing business, they also lure away customers, they also use the same business model, they also take away the things that the original business was conducting. If you're doing that, then it is not just non-compete, then it's a confidentiality breach. And the question will come of injunction. So you cannot use all of those earlier resources of the business. And that's how that, the original person can get some kind of success in doing that. Okay, because usually it is accompanied by people taking away customer lists. Okay, customer lists you take away means it is breach of confidentiality, and the court will act there. Okay.
Okay. Okay. Thank you.
Ma'am, so basically, what is reasonable is subject to interpretation of the courts, right?
Yes, it will be subject to the facts and circumstances of the case.
So that means in many cases you cannot avoid a litigation or a dispute in the matter of a non-compete or non-solicit courts.
No, you can see, like I said, no, wherever you are doing this, wherever you are taking away customers and all, you are actually damaging the earlier business. You are creating a loss for them. If you are developing something reasonable for yourself without working in a manner which is destructive for the former business, that is reasonable. But if you were acting in a way where it's a damage, then for their perspective, it is reasonable for them to restrict you to do that, right? So you have a right to carry on the business, but not in a way that you purposely damage someone else's business.
No, I got it. But what I meant was like, so whatever said and done, like if in the case of a non-compete or non-solicit, so necessarily imagining that the person who's exiting the business has only that particular knowledge, then he is starting a new business. So invariably there might come a situation where there may be disputes and it will go to court or it will go for arbitration. I mean, that is what
maybe. But skills is one thing, and taking away business resources or business knowledge and models and everything is another thing. You have a particular skill, that skill only you have, you use that skill for doing your own groundwork and developing your own model and developing your own stuff, right?
Yes, okay, that is clear. Yes, okay. Now I understand. One more question. So, in some companies, they have a restriction clause on the employee not joining a competitor.
Yeah.
Say for somebody in sales or somebody in R&D.
Yeah.
So, is this restriction also somewhat like a non-compete? And in that case, what does the employee do? Because again, it is his only skill that he is left with. So if he is restricted,
joining a competitor can become very tricky actually, rather than starting your own business. Okay, yeah. Because again, the situation will come is that how much of the existing business's information are you taking to the competitor and how much of skill are you taking to the competitor? You are taking your own skill that you have developed in the business is fine, but you taking the information, the business model, the structure, the processes, the client list of the former business, this is damaging. And then, if it is proved, it will be a reasonable restriction, right?
I have an answer and a question both for Kavita's question. So yes, in sales and marketing, client list is the most important thing, which mainly, these employees take from one organization to another. So this is not complete restriction. This is kind of a partial restriction. That sales guy is open to join any company apart from that industry in which this company is working currently. So he's not completely restricted.
It's not restricted, exactly.
He can go and work for any
competitor. You cannot join a direct competitor.
Yes.
Right?
Ma'am, just one question. So this clause comes under what? If I have to put it as a clause for the employee of such a company that you will not join these 4-5 companies which I've listed. So what under what do I put this clause?
It will be called non-compete clause.
Okay, thank you.
That's the heading it will have.
Madam, if there is a scenario wherein my skill sets are matching only with the competitor, or it's monopolized with one or two,
it can be.
ऐसा दुनिया में नहीं होता है.
That can't happen.
Huh? Yeah.
You can't argue that. It's not a logical argument that it is matching only with the competitor.
Well, but then see, how does the employer, the previous employer, even know whether the employee who's leaving their organization is going and divulging confidential information or sharing customer list or client list? How at all would the person know? I mean, what control mechanism would we have?
When you come to know. That is, your business will start getting impacted. Then people will start researching what is happening.
Like I have an example for this, just a short one. So like I have seen this in Kota, there are many these IIT classes and all that. Okay, so you can compare it with any of your places of choice. So when a professor who is renowned, a physics professor, maths or whatever, teaching in your classes, who has a name, just as Komal ma'am said, students know such professors by their name, and that's why they join the classes. And when such a professor leaves one organization and just joins another, which is just across the street, who is a competitor, and that same classes can actually see the drop in students the following year. So the students shift from that classes to another, and that's a clear proof that that has impacted.
Yeah. Yeah.
That's a good example. Thank you.
Yeah, but in that they are taking a skill, Mitali. They are not taking the college's business model or the college's way of functioning or that. They already have a skill. And they were not going to a competing organization and doing something of their own. Also, people know them for their skill. It's not because of the colleges, like, they're not taking the college's way of teaching or something like that. If they were taking that, then you will be able to stop it. But what
Ma'am,
we
I
are
just
doing
shared a
is
real life example. Like these classes, you
yeah,
might
yeah,
be
that
definitely aware of.
it is
So they
very,
don't just go there;
it's
they
very real.
actually take students also. So like,
Yeah, that's why we recruit some popular people in that matter.
right.
If I know that some professor is running that institute, if I'm starting an institute, I will take the main person from there, because I want the person along with his clients. That's how practically it works in India, especially. So
But
that's
to
why I want.
understand,
that you are giving is absolutely skill based. Now, this is absolutely skill based. Now, it doesn't happen in corporate sectors as such, because even though you have skill, you are functioning in a specific environment. You may have a really brilliant skill. People may know you by all of the things, but there is a team, there is a business model, there is a client list that you develop together with other people. Okay, so it's not only you. In corporate situations, generally, it will not be a situation where it's only you. Now, in this,
But
this
even
is,
in corporates, when one senior person like a manager, for example, a general manager of some division, he leaves, along with him, his colleagues also apply for the same company and they go. That's what is happening everywhere, which I'm seeing.
if they're going of their own free will, you can't stop.
Yes,
Yeah,
ma'am. And it's often seen in a law firm also. Like if one senior partner leaves and joins the other, law firm, the junior advocates and the people working under him tends to leave as well. Isn't it?
And if it's of their own free will that they are leaving, you cannot stop them. Like if
so basically, there's no protection against such lateral movement.
yeah, there isn't. If it's happening of their own and there is no solicitation or provocation, it's not. But just think of this, like, see, it's at the end of the day, it's war. You take away someone else's, someone else will take away yours. So you can't stop talent from training. For that, it is like, the business to create an environment where people are not going to leave. Okay, but you cannot have a situation where they are taking the business model, the processes, the customer lists and everything of the business to somewhere else. That is damaging.
So,
Right?
Komal, is it possible to stop a skilled person, from going either to a competitor or starting a new venture altogether? Is it possible to stop that person or not?
Direct competitors, yes, because you will insert that clause.
I'm saying this: the person who's going with skill, like she just gave the example of a teacher.
Even still, see, there are some point of time there is an implied assumption that if you will take that information with you. Okay.
The person is only taking his own skills, acquired skills. That's it. He's not taking any data.
It's very difficult for someone to prove that. That is why reasonable restrictions of non-compete clauses exist. So you don't want someone to join a direct competitor. That is what you are prohibiting. You're not prohibiting even people in the same industry.
So what I infer from this, that this clause must be used to harass and even exploit the mid-level executives. That is what this clause is mostly used for.
I don't think so. Think so.
Because you'll not have any clear-cut proof of this, and because the company owns a lot of the legal battery of lawyers and all, they'll just file a case against any executive who's leaving them, even if they do not have a proof or something.
At the end of the day, if you are going and joining a direct competitor, the company will have a problem, because it's very difficult to assume that you will completely operate in vacuum of without, like, having your knowledge of that model somewhere, because it's a competitor. It's a direct conflict of interest. You will want to take advantage. Okay, you will want to take advantage of your knowledge of the competitors' systems and everything.
So I'm just, I was talking in that context, which the lady just referred, the coaching institution.
Yeah.
So that context where the person is skilled and he's taking his own skills.
It's
not
a
the data.
very different example to corporates.
Okay.
Just to add on, that's where we have this concept of garden leave that's used in most of the corporates, where you say for next 6 months, I will pay you the salary, please don't join elsewhere, where you're protecting his right to livelihood so that it is not contested. At the same point in time, during that period of 6 months, you will have new innovative strategic decisions.
Madam, one more short question. I've come across where a special training is given to the employee, probably sending him overseas for a particular training. In such cases, only such clauses are generally used, was my understanding till now.
Okay, let me tell you, whenever there's any sort of a special trainings and if the company makes an investment, there'll be a bond clause which says for next 12 months, you have to work in this organization only. If not, you have to pay back the cost to us and then leave. No company will make investment on you when they feel that there is no returns from. And if you opt to pay back and then go, then again, they'll impose a clause saying that if this is a very highly skilled, you're not supposed to use it under the competitor and give the list of competitor industry. So this has to be looked more from a case-to-case basis. And I did hear about the customer list, right? What happens, I know if it is a mid-level person, it need not be always a manager who takes the customer details and work, but it may be someone in a very low level, JL2, JL3, who's just doing a SAP entry, but he has the customer details. But company think, what does the JL2 level person know? And you may not even impose. But I have seen in my own organizations, they have taken the entire customer details. It was a very JL2 level guy, took the details, he went and joined the competitor because JL1, JL2, they felt it is not a very risk profile. He started connecting with the respective customers, and customers very easily know him, thinking not because of my company name. They knew him because they have interacted with him for past 2 years. And they said, yes, we are happy if you're giving me the less cost. He knew at what price the packages will be booked. He said, I'll give you less than 20 rupees, less than. But when slowly the customer started deviating in the period of 2 months, who were for a long-term relationship, this was identified. And when we went back to the customer database, from where did this go? Who was the person? From when did this deviation start? We could figure out this person. Then we directly wrote an email to the organization saying that, yes, this employee is us and he is using our confidential data. Indirectly, you are also infringing it. You've taken a person. Then we had to go sit and negotiate with them, discuss, and he was actually terminated from that organization as well. So this is always looked from a case-to-case basis. How do you handle it?
I have a question.
Yes.
Yeah, this is the last one. Then we'll move to, otherwise it will stop the NDA and we want to discuss that. Okay. Last question.
Yes. So basically, suppose one person leaves the company and you have that non-compete clause, and that person joins a new company that is at you can say budding level or just established, but within a time period, or you can say 6 months or within a frame of 1 year, that company grows and becomes one of the competitor among the companies you work for. Will that clause still apply?
See what happens, you have to think in what angle. As an instance I gave you, most of the organization in a very low job profile, right? As you said, a budding person, a fresher, these non-compete and non-solicit clauses will not be much more invoked on them. See, even if you are a fresh lawyer who is just a graduate, maximum what will you do in a law firm? You will just review a few documents, help in Xerox print. Reality is that one. And you will tell your partner, the senior partner, so this is the research. But do you have visibility of what was the strategic decision? How did this come about? How was this legal opinion interpreted? How did your final senior partner arrive at a conclusion? How was the business transaction done? What advice did you give to the client? Definitely you will not have that visibility. Very, very limited. So under those circumstances, okay, let me complete. Under those circumstances, even if you have a non-compete and non-solicit clause, he joins the competitor, and if you don't see a risk of him sharing the details, it is usually not invoked. But if a senior partner is joining, like from JSA to Amarchand and Mangaldas, then you have a threat. And if it is a different subject matter, it is still fine.
Okay. Actually, I was talking about some skilled person who leaves one company and then joins some startup or some new company that becomes a competitor within a short period of span. So will
See,
that
a
clause
skilled
apply to
person,
you?
okay. If when it is a skilled person, and if the company grew merely on their hard work and not based on your customer details, not based on your vendor details, your strategic decisions, it's absolutely fine. There is no infringement per se that is done. Here it's a very new business which even you didn't think of. He's a new startup he's joined and he's used his own skill, and that is perfectly all right.
Okay, thank you.
I just had a small question. I'm sorry, it's been a lot of questions.
Last, then we have to move because otherwise.
Yeah. I'm sorry. Or should I just hold it until the end? I'll just type it somewhere and hold it to the end.
Is it related to the concept?
It's more of in practice.
Let's do one thing. Let me explain this clauses.
Yes,
To
okay.
draft.
I'll wait.
Okay, then let's take it together. Okay, now let's look at how to draft this clauses. I'm sure most of your questions will be resolved here. Firstly, confidentiality. As a very clear, you need to scroll up, Komal. So the very first thing is, in case of confidentiality, you need to know at which stage is this happening. Is it during the discussion phase? Then you have a NDA, which we will discuss in detail, where there is a preliminary discussions and negotiation happening. Nothing is concrete. Or is it during the master agreement, where you have a very explicit confidentiality clause that has been called out? That's the first thing. As a person, as a lawyer, when someone come to you and say that I need a confidentiality agreement, understand when and what structure is it happening. Point two, my personal and sincere advice to all of you is, please don't do a copy paste job in confidentiality. I've seen most of the interns or most of the good lawyers also do that. They just go to Google, just see one confidentiality clause, copy paste plan, projects, everything under the sun. What is there? Everything becomes confidential. Please don't ever do that. Customize your confidentiality clause. Understand for which sector are you working. For me, if I'm in a real estate in-house counsel, for me, my confidential data is my next forecast of where am I taking up the projects. If there is any new JVs or investment agreements that I'm doing, what are the mother documents? What are the land, the holdings of that particular company? This become my confidential data. If I am in an ITS setup, for me, my confidential data will be my software development. If there's some R&D that I'm doing in case of a shipping company, my cruise, that is itself per se a confidential details for me. If I'm so understand which business are you really into. If you're a consultant and if a person is stepping out, in that case, maybe the big project that you are handling, and you very clearly call it, you are handling a project which is still existing. You're not going to go and join the competitor who is still there in that activity. So understand the business and carve out your confidentiality well. Like if you are in a marketing, like for Amazon, their next forecast, their marketing strategy, how are they going to develop their web design? How is the web portal, how well is it going to be customer friendly? These are your confidential data. So please understand the sector, where is it going to happen, and then carve out your confidentiality. Once you carve out confidentiality, very important thing is confidential information is during the term of the agreement and thereafter. As I very clearly called it is one of the survival clauses. So it is more of a negotiation. Minimum of 12 months of confidentiality should be there. Please don't go less than that. Minimum 12 months. If you maximum that you can negotiate is up to 5 years. Beyond 5 years, nothing works, because any technology industry, once in a year, your technology changes. Your marketing strategies change once in a year. The forecast changes once in a year. So minimum 1 year of confidentiality, please negotiate on it. Maximum is 3 to 5 years. If you get, that's a best negotiation. But as a lawyer, 1 year, it's non-negotiable. After that, I think those internal notes on confidentiality. Not this one's the upper. Not completely about that. No, it's down.
This one or the other one? This one?
No, draft. Yeah, that one. Okay. Yeah. So once after you decide, then decide how are you going to bind it. Is it going to be unilateral or is it going to be bilateral? I hope all of you know the difference. Bilateral, where both the parties will be bound by the confidentiality. Unilateral is only one person will be bound by it. So here again, the negotiation plays a very important role. If you are a person who is giving the information, okay, keep that confidentiality as much as wide as possible, that the other person is not going to breach it. But if you're receiving the confidential information, keep it as narrow as possible. That is a negotiation tip for all of you. So please understand, for whom are you representing? Because giving the details is still easy, but retaining that details, ensuring that it is not revealed outside is very important. So if you're receiving it, keep it as narrow as possible. If you're giving those confidential data, then keep it as wide as possible. Next one, you will have to understand from the context to what extent is it feasible to mark a document as confidential. If you see, I don't know how many of you have exposure, if it is a big investment transactions, right? The moment it comes to the legal or secretarial team, on top of it, it will be very clearly called out, this is confidential document, which means apart from that legal people, no one else has a visibility to it. So you have to very clearly call out whether all the details are confidential or only those details which is marked is considered to be confidential. Because at times you may just pick up a call and say that, okay, this is what we are negotiating. Is this still fine? It may be just over a telephone. Can you even call that telephonic conversation? If so, then you will have to clearly call it. Any communication that happened between the parties or their representative during this JV transaction, irrespective whether it is written, oral, everything is confidential. If you keep it so wide, you have to think, can you justify it if there is a breach? If not, you can just restrict it to saying that only documents which is marked is confidential by nature. So that is again case-to-case basis, you need to assess. After that, you can't call out every details as confidential. Okay, there is always certain amount of exceptions to it. If a regulator come and ask you, if there is a sudden raid and there is some regulatory authority, income tax department is asking you, then you have to mandatorily reveal it under the law. If something which is already known by the opponent party, the vendor already knows the details, then it is not confidential. Already available in the general public domain, then it is not confidential. So these are the 3 important exceptions that you need to be mindful of. So the 5 important tips for you while drafting. First of all, understand in which stage is it happening. Is it during negotiation or at the time of execution? Second, please don't do a copy paste job. Understand the business. Keep it very crisp. Keep it very carved out really well. What is confidential for you? Talk to your clients, talk to your business people, understand, then draft it. Decide whether it's going to be unilateral or bilateral. If you're a recipient, keep the confidentiality as narrow as possible. If you're a provider of the confidential data, keep it as wide as possible. Check on the feasibility on, I'll repeat it, check on the feasibility of marking the documents. It's not required all the documents need to be marked confidential. So you can decide on case-to-case basis whether only documents which is marked is confidential. Next one is exception. All the data are not confident, even though it is confidential, under few circumstances you need to reveal it. When it is demanded under the law, when the court demands it, regulator demands it, which is already known to public. It is like a Satyam case, or everyone knows about it today. You can't call it a Satyam case confidential. Everyone knows in the public. Next is whenever any details is already known by the vendor. Vendor already has a knowledge of it, then it is not a confidential data. So these 5 tips are very important for you while drafting. An additional thing is, how are you going to consider at the time of breach? Breach is you have shared the confidential data, he's breached it. What are you going to do at that point in time? 2 things. One is you can go before the court of law and claim the injunction order. That is the one item, that's injunction, which is provided under law. The second is damages. So always any breach of confidential data will be unlimited liability. So I don't know how many of you know what is limited and unlimited liability. Limited liability is where you're going to cap it. For example, if there is a breach, you can claim only 5 lakhs from me, not beyond it. So that is capping of liability. Unlimited is X amount. You say that the moment there is a breach of confidential data, I can claim X amount of damage, considering my business loss, my reputational risk, the financial loss that I went through. All those things will be considered and I can claim it from you. So always in the agreement, especially in commercial agreements, while negotiation, this is one clause which will be very highly negotiated. They always try to cap, the other person tries to cap, but for you, you should always keep a confidentiality, infringement of IP, data privacy breach, all of them as an unlimited liability. Okay, so this is the few tips at the time of drafting your confidentiality clause. I just saw one question. Okay, let me take this. Okay, mother deed, real estate documents. I don't know how many of you have exposure. Maybe real estate documents have something called as mother deed. That is, from how did this property really come? Who was the first owner of the property? From there, how did it, was it a succession? Was it a sale transaction? How did the entire property, what happened in the property before it came to you? That entire narration of it, the entire document set is known as mother deed. Okay. So moving on, non-compete and non-solicit. Yes, this is also something which has been very closely connected with confidential information, because just because a person has a confidential data, you impose a very strict non-compete and a non-solicit clause. So non-compete, we have spoken. First of all, understand the business. Okay. Second, this competition, as I very clearly called it should be reasonable. You can't just make a very vague statement. You are not going to join any ITS company. If you make it like that, it means he's just skilled. He's a software developer. Where will he go and join? What will he do for his livelihood? Instead, you can say that you are working in TCS, XYZ, the 5 or 10 companies are my competitors. Apart from these companies, just go and don't join those companies. Apart from that, you can go and join any other company. So call that out competitors very explicitly. Next one, reasonable. Like for example, I gave you the chef example, right? His skill is cooking. So in Bangalore, don't work. Elsewhere, you can just go and work. That is still fine. So you carve it out with a geographical region, so that even tomorrow when a person contests it as a in-house counsel, your interest, your company's interest will be protected. Next is a non-solicit clause. Non-solicit is where you are not going to solicit your former employers, vendors, employees, customers. That becomes your non-solicit clauses. So one thing you are going to say that non-solicit clauses would be like, this is my customer details, right? You're not going to solicit my customers. You're not going to solicit my employees. Like you can even say the same department. There are few times when it is a general manager of a company, we very clearly call it. You're not going to solicit your own team members for next period of 12 months. However, there is an exception to it. If, okay, when you firstly, whenever you're carving out a solicit clause, be very mindful. What happens? I am a company, it's a parent company. But many a time what they do, they hire him through the subsidiary company or through some affiliate company and ensure he starts reporting it to you. That's a very tricky way of solicitation, where you don't do the interview, you don't do anything. However, you'll instruct your affiliate company to do the interview process, everything, saying that he's a very good candidate, please get him from there. So this happens. So whenever you solicit, you can even carve out, you are not going to join the competitor and you're not going to solicit the employees of your team, either through the competitor company or through its affiliate subsidiaries. You're keeping it as wide as possible so that your solicitation clause is very well carved out. Second thing, an exception to is a general advertisement. Just because there is some posting in LinkedIn and your manager has gone and joined there, you can't affect someone else's livelihood. Through general public advertisement, when there is a normal recruitment process that has been followed, then it falls under the exception category. Okay, so these are few things that you need to be very thoughtful while drafting. Understand the scenario.
Exception.
For which one?
Just
non-solicit?
Yeah.
Solicit? Okay. See, today I'm the general manager. My solicitation clause said that you are not going to solicit your team members, right? So I am not soliciting. Neither I'm interested to solicit as well. But in my company, there is a vacancy, which is for a JL3 or JL4.
Yeah,
I posted in LinkedIn,
got it.
and everything. He can directly apply and you can do the interview. It is a normal recruitment process. Then there is no bar to it.
Clear, ma'am. Thank you.
Yeah. Fine. Any questions on this drafting? If there's nothing, then I can help you with drafting of NDA.
These clauses, in addition to employment, it can be in other agreements also. And it will depend on, like, again, the interests of both the parties. On non-compete and non-solicit clauses, it can be there in investment agreements also, shareholders agreements also, can be in distribution agreements also. If you remember, we did one example where we said that the distributor will not enter into an agreement with a competitor for distributing similar products. So they can be in, but in employment agreement, they are the most prominent, basically. But it can be in other agreements as well.
And suppose in the agreement you specify the name, then the restriction is only with regard to those specified names only.
Yes, if you very clearly call out who are your competitors, then it's only for that competitors. He can go and join like a very small company. It is still fine. Because for me, my threat is competitors. My threat is not some new startup. That is definitely not a threat to my business.
So it can be specified in the agreement.
Yeah, you can. We still go ahead and do it. I'll tell you, even in the lease deeds of late, right? If a company is taking up lease premises, like an entire tower, we even call out saying that, please don't give this lease premises for this for 3 to 4 competitors of mine. The intent is like today they should not see Merck's name as well as my competitor name in the same building, so that it creates a confusion. Even in leased premises, we are doing it off late.
Okay, this was a nice example. Yeah, thank you.
Ma'am, I have one doubt.
Go ahead.
Can I ask the developer to not to develop similar software for the companies who are doing similar business like me?
See, don't keep a statement very vague, right? See, as a lawyer, one thing we like every time I tell this, whenever you draft anything, think of litigation. Come backwards. If this is a litigation point, and if I say that you don't develop a similar developer and similar things, like for techies, everything is similar. For me, if I see any profile, everything is so similar for them. You may just say that it's just one different will be slightly in Java or Oracle, very minute details will be different. Otherwise, everything is going to be similar. So please call that out explicitly. Like you are a developer for so, but one thing, if he's skilled only to develop that particular item, then you can't impose a complete restriction on him.
So how do we specify the clause, make it more specific?
Yes. So you say that you are a Java developer. Like I'm giving you an instance. You are a Java developer. You are not going to develop XYZ development which happened in this organization in your competing companies. Give those 5 competitors. Be very clear. Carve it out well. So that he can go and develop apart from this XYZ, any other Java developments that he wants to do, he can go ahead and do it.
So you are saying in litigation that clause will be simply treated by a judge or judicial body as a not
because you should see the reasonableness. No, tomorrow an employee should not come back and say that this was my bread and butter. I'm skilled to develop only this. If they impose a restriction on me, what will I do? A judge will not see what is Java Oracle. He will just see what will happen to his livelihood.
In this case, actually, the question about it's not about non-compete. It's about intellectual property. So your website and content and everything is your IP. If you have taken the IP and if someone else is taking exactly the same IP, then the question comes is infringement, not non-compete. Okay. So you will not go and catch the developer, you will actually go and catch your competitor, say that you have infringed my IP content.
Got it. It will not be covered under non-compete.
No, I mean it's very difficult to stop the person from doing or developing that. But if someone else is taking the exact same IP as you, then you will go and catch them. No? Why will you catch the developer?
Got it.
Great answer, ma'am.
So it will be something like you cannot use the same work product from another organization to the when you are joining to a new organization. Is that correct? Because that is how we can restrict. Then because as we just saw, the person will have the same skill and he will be recruited only for the development skills. And if he is not supposed to do the work, then that is not the purpose of his recruitment, right? So it should be like the work product is not shared. Right?
I didn't get her question. I'm so
sorry. Yeah, even I didn't get the question.
No. So what I was trying to tell is, so when we are talking about the Java developer, so his main recruited him if he is joining to a new organization and his skill is to develop the JavaScript, right?
Yeah.
So what he is supposed to do is he cannot use the same work product what he's done in another organization.
Yeah, because the IP belongs to you.
Yeah, exactly.
Not because it's non-compete or anything.
Yes. So the JavaScript for products can be the same, but it should not be the same product what he is going to develop into the another organization.
Yes.
Yes. New entity.
Okay. Yeah. Okay.
Can we go ahead with NDA?
Yeah, we should. We should. You want me to open the draft, the template?
Yeah, we'll show the draft. No, we can
Let me do
discuss
that.
that. Maybe when the draft, I'll just explain when we do that. Non-disclosure agreements, as I've very clearly called out, before executing a master agreement, in the preliminary stage of discussions, the parties enter into such NDA agreements. So it is nothing is still finalized, but they have some intent to make a transaction happen. Usually, whenever there is an investment a company needs to do, like a X person needs to make an investment in the company, he wants to review the documents, like due diligence of the entire document. So then you execute an NDA with him and you give the due diligence document. Even when you want to purchase a particular or lease a property, we enter into an NDA, we do the due diligence of the land documents, and then we go ahead and do the lease deed. So NDA is basically in the preliminary discussion stage. Even JV, when two different investors want to come and start up some new project, even at those stages, they do an NDA, something which happens even before the main commercial contract. An NDA will be executed. An NDA, what happens many a time, once they do the due diligence, they may feel that, okay, this doesn't work out for us. They can just terminate it and they can move on. But if it is successful, then it goes with the follow-up agreement process. So I'll explain further. Firstly, you have to give a title, non-disclosure agreement. This itself that very clearly calls out it is happening at the preliminary stage. And another instance when NDA happens is when they are hiring a executive level people like managing director or something like that. Most of the companies, they execute an NDA 1 month before of this individual joining, because in listed companies, especially when MD is joining, you have to make all this stock exchange informations and all this. At that point in time also, just to give him the entire strategic information of the company, they execute an NDA, start giving him all the strategic information, the forecast, how company needs to be. They train him up well and then make an announcement in the media, make an announcement to the stock exchanges and get him onboarded. So in most of the companies also, this NDA will be executed. So firstly, it's very common how you mentioned, give the title, NDA, then you're going to tell when is this going to be executed. Now, this is a bilateral NDA. As I told you, whenever you draft, you need to decide whether it's a unilateral NDA or a bilateral NDA. In case of unilateral NDA, right? One second, scroll up, Komal. Scroll up, scroll up. Up, scroll up. Okay. In case of a unilateral NDA, here you will be mentioning the, instead of saying disclosing party, receiving party, you will be saying either service provider, service recipient. You give this parties like how you do in the other agreements. You do that like a client, service provider, if it is a unilateral agreement. But if it is a bilateral, you will be using the term disclosing party and the receiving party, because here both the parties are sharing one or the other information pertaining to that particular transaction. So you use this disclosing party and receiving party. So decide whether it's unilateral or bilateral, and based on this, nomenclatures will be there. But usually in NDA, it is bilateral itself. Then scroll down. Next is whereas. Whereas is your recitals. You're going to say what is a disclosing party's business activity. Now let's take an example of investment, like a joint venture, like two parties, two different domain people wants to start some e-commerce platform. Okay. So here the business, you have to tell what is the X person's business, Y person's business. Please mention all those things and tell what is the information that is going to be shared. As I told you, please don't do a copy paste here. When you say define here, define what exactly is it going to be shared. Like, is it something one person may be a tech company where they are very clearly calling out what is the software, what is the IP address they have, who are the people who are working under them, have they have a projects done before, or is it something R&D happening at their end, and this information is shared with the other person. Now the other person would be someone who is already like e-commerce, he was before working somewhere, but now he's inclined to make an investment here. What is the data that he is going to share? So explicitly call out what are the confidential information that will be shared in this particular transaction. That is where you have to define. Next is mutual promises. This is a general statement where we say both the parties are going to do it. Next is confidential information. Confidential information, yes, it's been bold because it's already been defined here. We will say all inventions, ideas, research formats, human readable. So define all these things. So as I called out, just don't do a copy paste of this. Understand your sector, understand the business. If it is a real estate, land documents. If it is an IT, it will be your software. If it is something apparels company, then it is going to be your vendor list, your fabric details, your forecast that you're planning, your customer details. So explicitly call all those informations and define it well. Okay. So non-public available information, marketing or finance details of the company, any contracts that has been executed. So this is something which you need to assess, understand the sector and draft them. Scroll down. Now is non-disclosure and confidentiality. So as I told you, first thing, confidential information is something which is privy only to those two parties. So very clearly we'll have to say that without the written permission, the other person is not going to reveal this information to the third party. Next, after that, you should also promise that you will take all sort of a reasonable care to ensure this confidential detail is not being revealed. So that it means like you as a founder, you've taken this confidential data, but it is important for you also to cascade to your team, like your legal team, secretarial team, marketing team, saying that this is a big transaction which is in pipeline, but these are the informations that we have. Please don't reveal it to the third party. Please don't reveal it to the market. It is still something which is not finalized. It's still under the negotiation phase. So you should promise that you will ensure the proper integrity to safeguard this data. Next is if there is any sort of even if by mistake, if you've shared it, accidentally you've disclosed to someone, you should be in a position to retrieve it and protect the information. And you should say that only to the instant of due diligence, you're going to use this confidential data. Apart from that, you're not going to make any sort of a profit out of it. The intent, what you call out in the recitals, the same intent has to be used at the time of confidential information. So this is something you have to explicitly call out. That is, you're not going to use it for making any profit. You'll cascade and ensure the integrity of confidentiality is being maintained. You will ensure that it is not revealed to any sort of a third party. Now, as I called out, there are few exceptions. Even though it is confidential data, under few circumstances, you will have to reveal it. Maybe which general public already knows about it. Government authority or a court or regulator demands it, or it is already in the purview or a knowledge of the other person. Like you are a founder giving information, but the other investor is already aware of it. That there is nothing called as confidentiality. So these are the exceptions that you need to call it out. And this exception will hold good even when you just draft a clause in the master agreement also, those exceptions will be there. Next is, injunctive relief. Very clearly, I said that there are two remedies that has been available in event of the breach of confidential data. One is injunction. You can go before the court of law, have the injunction order. The other thing is claiming the damages. As I said, always keep a liability unlimited. I'll repeat it, Pankaj. So always a liability should be unlimited. Don't cap your liability saying if there's a breach of this, I can claim only 5 lakhs from you. Never do that. Keep it unlimited liability for all the laws, business laws, financial laws, everything, reputational laws. The other person should bear that loss. So keep an unlimited liability in an event of breach of confidential data. Dispute resolution and governing law, yes, laws of India will be governing. Dispute resolution, you can decide where is the arbitration tribunal, where is the court set up. If both the parties in Bangalore court will be there. So you can decide. It's a negotiation point again. Next one, you're going to talk about the reservation of rights, saying that any activity that he is going to do, it will be time bound, no forbearance, any sort of relaxation in action at any time will not be there. Within the time frame which has been there, you are going to ensure this confidential data. Confidentiality is not something that's perpetual forever. You can do it. If it is a particular, like due diligence is just 45 days time period. You have the rights, you have to ensure that right within that period of time. Next is partial invalidity. It is like a severability clause, where we'll say that if any one thing is not in a position to be, if something is not in a position to be invoked, then other things will be valid. Only that particular clause becomes invalid. So that is nothing but a severability clause. Next is indemnification, where there is a breach. If there's some claim done by any third party or a loss, you have an unlimited liability, which will be called out under the indemnification. So this is how your entire NDA will be there. Very important, same tips I'm going to repeat. Understand the sector, draft that confidential information, define it really well. Next one, you should always have the bilateral in an event of NDA, because both the parties are going to share the confidential information. Exceptions, if the code demands it, you can reveal the confidential information. If there's a sudden regulatory demand, like an IT department is coming and demanding, you can reveal it. Already known to the public, then it is not a confidential data. Already in the hands of the other person already has a privy to that information, then it is not a confidential information. Okay, so these are the 4 exceptions. Call out those exceptions. Then you have 2 reliefs. One is the injunction under the law, another is the damages. Always keep it unlimited liability. Never cap it. The confidentiality clause, never ever cap it. It's a very highly negotiated clause. Then rest is a very common thing where you talk about the governing law, severability clauses. Please understand the sector and draft the NDA. Komal, you want to add anything?
Yeah, anyone has any questions on NDAs? These will be entered into even before any kind of discussions or anything takes place, because in many transactions, the information sharing is inevitable. Like you will have to share the information for someone to do their work. And for that purposes, you want to bind them not to share that information to other people, right?
Madam, the master agreement that follows this NDA would be in the same context, or generally, or multiple master agreements.
So you can have transaction documents which follow, which also have a confidentiality clause. But even before those transaction documents kick in, you can have a non-disclosure agreement where information that is being shared between both the parties, even before they enter into a transaction, gets locked. Okay, so the other party cannot disclose or share it with other people. Sometimes this is so relevant because even like, I think Nishmita also said that even if the fact that someone is going to enter into this agreement can impact the market and everything, right? So like you have companies, listed companies, they are going to enter into an agreement, they are going to get a huge project, they are going to do that. It can become very relevant even if they have not actually done that yet. Okay, they have even not entered into an agreement to sell certain things. They have not entered into an agreement to get into a joint venture or sign combination or acquire or do any of those things. They have not even done it yet. And yet the fact that that transaction is going to be entered into is also very relevant. So therefore, they will enter into an NDA well before that transaction actually happens. Okay.
So the transaction happening is the master agreement.
It will through a transaction document, not necessarily master agreement. It can be a document which is the base of the transaction. It can be a share subscription and shareholders agreement. It can be a joint venture agreement. Okay.
Okay.
Depends on what the transaction is.
Yeah, I got it. Thank you.
All the affiliate subsidiaries and holding companies as a party in the preamble. Is this valid? Don't the other companies have to pass a separate resolution for authorization? It will not be affiliates and subsidiaries, in my opinion. It will be successors and assigns. Okay. The reference to other people will be to successors and assigns. Even for companies, it will be successors and permitted assigns.
No, I have actually seen contracts where they do refer to affiliates and subsidiaries. I have seen.
I'll tell you the intent there. What happens? Maybe the parent company is entering this transaction. You say that I don't continue with this. This negotiation point is not with me. Tomorrow they use the subsidiary company to go with the competitor and understand all this due diligence to crack the business deal there. Just to avoid that, they do it.
Ma'am, I didn't get that. Please repeat.
Okay, so what happens is whenever there's any confidential data, right, like XYZ Limited, fine? You have 10 other dormant companies, which is your affiliate and subsidiaries. I enter into this NDA as a parent company and get all the informations. Tomorrow I say, I'm not happy with this business deal. Let's strike this down. But you have all the confidential data. Who is bound? Only this parent company is bound. Subsidiary and affiliates are not bound. Then what happens is always a risk where you share this information with your subsidiary, and in turn, subsidiary enters with the competitor and do a business transaction. Just to avoid that, they keep it under a very wide umbrella.
Okay. So, but is this valid? Because, I mean, what about the permissions that the other companies have to give? Because they are separate legal entities, right? So
yes,
they have to authorize some individual or managerial personnel to sign on their behalf.
But Kavita, don't you think that the parent company by default has this entire authority? It's in the very big umbrella, right? What is the whole intent here? Intent is confidential information should not be used or should not be infringed. If you go ahead and seek every subsidiaries, today companies have 40 plus subsidiaries. It is not business friendly to go and seek every resolution and do it. That's the reason we keep it very umbrella and say you're not going to do it either through your subsidiary and affiliate. If you remember, even in my earlier example, when we said that non-solicit clause, people say that I will not recruit that person because I'm in parent company, but they will use a subsidiary to onboard that candidate. That's the reason we say solicit by the company where you're joining or any subsidiary or affiliates of the competitor entity as well.
Sorry to interrupt. So actually,
yeah, I agree where Kavita you have a problem, but what the way in which people will do these transactions, you will probably have blanket resolutions everywhere. Okay, so like where it is 100.
So I'm just trying to understand the procedure, what goes behind this.
Yes, that's what I'm telling you. That's what I'm telling you. That where there are 100% subsidiaries, people will like in the first, second meetings and everything where these are formed. At that point itself, they will have like blanket resolutions giving authority to like, the main company or people who is a person who is a director of the holding company on the board of the subsidiary and everywhere to go ahead and enter or conquer the bind the company or things like that. They will give blanket authority and in lot of different cases. Usually they will.
Okay, got it, ma'am. So, but it has to be backed up by a resolution, right? I mean, that
yeah, it has to be. Of course, it will be. You can't bind a company without there being authority to it. But usually these guys will have common directors also.
Yes.
So they will give authority to the one common director to act on behalf of the board and sign in a blanket resolution.
They make that authorized signatory a common director elsewhere. So they somehow routed that way.
Okay, got it. Thank you.
You can have that same person like in an annexure, and that same person is signing on behalf of all 40 subsidiaries in the annexure because he's a director on behalf of all 40. And they will all have passed when they are incorporated a blanket resolution authorizing that person, whoever is the nominee of the holding company, authorized to sign on behalf of the company. You can do that, right?
Most of the time what happens in real estate, especially the founder of it will have this blanket resolution. He either plays as a director or authorized signatory and he executes the documents.
Yeah. Any questions?
We can take up the exercise.
I had one question. I forgot. I was
Yes,
just.
Aditya, you missed your
Yeah,
flow.
sorry. So my question was, when we're drafting a said NDA agreement, right? How far can, sorry, a non-competition agreement, how far can I stretch it to sort of limit his performance to the, so what is, where does it become unlawful? How far can I restrict him? So if because I really want to know how to, if my client wants the other person to not do anything, I want to know how far I can do to make my client happy. And if it is, how far can I, avoid the law or the hands of the law, but yet restrict that person's performance where it benefits my client. So where is that line that differentiates the two?
Yeah, Nishmita, you want to discuss this? I'll give you the line then. Okay, let's hear Nishmita's views on this.
Okay. So when you say that when it is a non-compete, right? One option for you, like I'm giving you practical instances how it works. You give them a list of competitors and say you're not going to join them. One thing you're going to do. Second, you're going to call out very explicitly what are the datas which is confidential, because non-compete and confidential clause are very closely interconnected. So you will clearly call out what are your like your vendor details or your customer database or whatever it is, your forecast, maybe a confidential data. You clearly call that out. After that, one more point, when you're doing this, please ensure that he has an opportunity to work elsewhere. Like if he is a skilled person, you say that from Amazon, you're not going to join for Flipkart, it's your competitor, but you should not stop him from joining any other e-commerce platform. That is unreasonable. So that thought of reasonableness should always be in your mind. So many, if you want, you can add further.
Yeah. Aditya, you were asking for the line. The line gets drawn where you believe that, the people whom this guy is joining, there is a definite conflict of interest. Okay, there are two people competing in a sector. It is very clear that if I want to win, I will have to beat you. Okay. Now, if that is the situation and you are allowing your employee to join somebody like that, okay, so that's where the limit is. But like where it's not, just imagine this kind of situation that it is Flipkart and Amazon, and then there is some xyzbazaar.com nowhere in line or nowhere near, then you can't go and stop those people, and your business is not going to get affected because he's joining that. So where it is very clear that your business will be impacted when they join that competitor, it is a competitor, and very clearly them winning means you losing. Okay, so that's why that's where the line gets drawn. That if it's very clear that there is a clear conflict of interest and you're going to impact my business because you're taking on an employment there, then that's where it gets drawn. But beyond that, you are not going to, your business is not getting impacted. Them joining someone else, the business is not going to get impacted because you are at a different layer in the market. You are in a different segment. You are in a different geography. All that things are changing. Your business is unlikely to be impacted. And them winning does not necessarily mean you losing. So then that's where that line is, right?
So, so the reason I'm asking this, yeah, it's probably, I think, Komal, you got where I'm coming from. No, the only reason I'm asking is because I want to know the element of unreasonableness. How likely is it for me to get trapped in it? So if I were to say, do not work for. So if I'm working for a real estate company, I say don't work for Magic Bricks, don't work for all those buggers out there, and you cannot work for any real estate company. You can work in your profession, but not in the real estate industry. Will that play out? Like say
that is unreasonable. That's an unreasonable restriction.
But
you can say, okay, I'm in Prestige. You're not supposed to work in Brigade or Embassy for next 2 years as in-house counsel. That is fine, because I, as an in-house counsel, I can work in ITS, I can work in shipping industry or something else. Real estate for next 2 years, it's reasonable for me because I have other avenues to work. But you cannot say that until your last breath, you're never going to work in real estate again. That's unreasonable.
And Magic Bricks is not
a competitor, first of all.
Yeah, they are
the other
aggregators.
e-commerce platform which you haven't. Here it is a competitor entry. Is that clear, Aditya?
Yes, and no, I'm just trying to figure out what that line is. So like as much as possible, I inconvenience the other guy.
If there is a project, then me and you both are going to compete on it, and we will fight each other tooth and nail. And if that's not happening, then you are not a competitor.
Correct.
Aditya, see, I'll tell you a very simple thing. Okay, just imagine you are an in-house counsel and a client has come to you, or you're a business person. This is how I always think. For my business, what is a risk? A JL1 level person who is a fresher who is leaving the organization, is it a risk for me? Just tell me yes or no. He's just a fresher. Okay, in my organization, there's someone who is a JL1, who is a very fresher. Is he a risk to me if he join my competitor?
No, he's not.
Correct. If the managing director is quitting and he's going to join my competitor, is it a threat to me?
No, unless he's like very experienced. No, he's not.
Yes or no? 1 second. MD is quitting. He has the complete information of the strategy.
I mean, yeah, obviously. If he has like all the things, obviously, yeah.
Yes. So what will you do? You have to work backwards. That's what I said. That's how drafting works. What will you do? You will clearly call out your competitors. You cannot say this MD should not be MD in any other organization. You will clearly call out who are your competitors. And that's where your reasonableness comes in place. Because you have details of the confidential information. So 2 options. Today in corporate, what works? You give them a garden leave for next 6 months. You ensure everything, right? Even their residential accommodation has been borne by the company, at times even up to 2 years. They send them to all exotic vacations. This is reality. This happens. And after that, you can go and join elsewhere. Or you say that for next 6 months, please don't join my competitors. After that, please go ahead and do. Because 6 months is a very vital time for me to change my forecast. Or we even say that during the notice period, please don't work. Be on garden leave, please don't work. After that, please exit.
Okay.
Understand what is a threat to you. The moment it is threat, you start protecting. It's like taking a vaccination. You know what is a threat in COVID, you go ahead and take vaccination. That's all happens in COVID. Simple example.
Thank you so much.
Yes.
To ascertain the reasonableness, judicial precedent plays a vital role, right?
Yes, it is always case-to-case analysis. Maybe as someone pointed out earlier, what is reasonable to me may not be reasonable to you. But you have to treat the holistic approach. As long as there is another option available to me, it is still reasonable.
So judicial precedents will expertise our knowledge. Thank you.
Ma'am, I have a question. What happens in case the executive directors of the banks, they join as the MDs of some other banks? In such cases, what will be is there some breach of the clauses, or what clauses are they restricted by?
So what happens in the bank is more governed under the banking regulations, right? You cannot go much in those details. First point number 1, you can't take the customer details. Someone from Vijaya Bank or Canara Bank nationalized, they have the specified rate of interest. They have a specified RBI governance. Repo rate is going to be safe. Nothing much can be done because these are more of a regulation financial institutions. They're regulated under the law.
But still they are the
there will be non-compete.
Clauses will definitely be there. It's not that you just allow him to go and join. Your non-compete clause will definitely be there. But how you look in an IT setup, how do you look in a banking setup is completely different. It's a sector difference that is there.
But we can't we can't write certain things that you can't join the bank in this particular period, something like that. Because
you can. Why not? You can. Just think of this, like, there will be very strong competition between the likes of HDFC, ICICI and Kotak to take customers, and they may be developing new products, and they may be, in process that this is a scheme or this is a new financial product will launch, and someone is taking that details to the other bank. There will be non-compete, definitely. Regulation is there that up to that certain extent they can't act in certain things, but there will be no.
Okay, thank you.
And one more thing, in reality, when any sort of such big transactions are happening or any rollout is in near future, in a very short stint of time, they never allow any top management people to quit. They'll ensure until the rollout happens, you need to be in the organization. Until and unless there's a grave termination, the posh case or something like that, then it's an exception if he's a criminal convict. But otherwise, if something in a transaction level, almost in the urge of completion, they still hold on to such resources.
Naresh has a question. Naresh, do you want to speak it? Naresh? Is that Naresh's question? Apple, Google, and Amazon?
No, it's
Kavita's question.
Kavita, okay, Kavita, what is the question that you have really? Because to my mind, Amazon, Apple, and Google are still different companies.
Yeah, their businesses are different to a large extent even now. But if you see, Google has the IoT device, right? I don't remember the name. Amazon has Alexa. So these kind of products and people working on these lines. And I think there will be a situation soon where you will have all these companies manufacturing the same kind of things and being in the same kind of sector or industry in a very short while. So, I mean, I just want to understand what would be the situation for employees who are in these companies. So, if they want to switch from Amazon to Google or to Apple, then you will be considering them as your competitors as well. Right?
Marisa Meyer shifted from where? She shifted from another entity to Yahoo, right? Right, correct? Where did Marisa Meyer shift from? Anyone aware of that? Where was Marisa Meyer before Yahoo? Where was Marisa Meyer? I don't remember, but guys.
Plead my ignorance, ma'am.
Oh, she joined a direct competitor.
She was in Google. Yeah, she was in Google and she joined Yahoo, which are both basically search engines.
Right? Google is no longer just a search engine. They are much more.
Yeah, but at that point of time, they were search engines basically, and Yahoo was getting like sliding down. Even still, like I'd say it's not there anymore now, but it was sliding down, and that's what she was supposed to do. So she joined from Google to Yahoo. She did. So I don't know what kind of non-compete or things these guys would have had, but it is happening. Depends on what they have in their agreements.
I just saw a group message that there is going to be some dissection club every Wednesday. So probably we can dissect these three companies in the first meeting.
Yeah. Yeah. Okay. Any further questions that you guys have?
Ma'am, I have a doubt.
Yeah.
I'm still not clear with the concept of non-solicit clause. Can you please explain?
Yeah, it is simply that you are not going to, let's say, if I put it in very simple language, provoke other people to leave and join. Okay, whether it be employees, whether it be consultants, whether it be customers, you are not going to stop them from dealing with your former company, or you are not going to provoke them from leaving the relationship and joining another company's, things like that. That is solicitation. So you will not do that.
Okay. Okay, ma'am.
Yes. Rajiv has used a better one. You're not going to entice, you're not going to lure away. Okay. Okay. Any questions Now,
Ma'am, I'll ask a last question.
yeah.
Ma'am, somebody gave example of a law firm wherein one senior partner leaves and then junior follows, so things like that happen. I missed that point, your answer. So, although the senior partner has not, you know, himself approached these people, but there, uh, can we like assume or like what things happen? How do we put this when we go ahead for litigation in such cases that this was due to soliciting?
If their agreement has a non-compete in it, and you're not, another thing is you have to think of what is the kind of sector that these guys are into also, the size of the firm, all of these things you have to think of. Okay, for example, when someone is going from a tier 3 firm to CAM, they are not a competition. Okay, someone is going from a CAM to a specialized niche area firm, they're not a competition. Okay, and that's the kind of things that usually happen. Okay, people move, in fact, to smaller firms because they have they're looking for different things. Like they're not looking now just for money and name and all. They're looking to create some things. So then people will leave from the likes of CAM, set up their own small firm, which is nowhere in competition with CAM, or join another smaller companies. Things like that will happen. But it will not be direct competitors. Why don't you Google and find it, Kavita? The real life example of litigation on non-solicit clause. I can recommend at least 3 Bollywood movies that you guys can see.
Please.
Anyway, let's not joke around. There's one movie called Rocket Singh. I'm not sure if you guys have seen that. That has these elements. There's a movie called Corporate that has these elements like competition elements, confidentiality elements. A very old, very old movie when someone was talking about real estate is called Diwar, like a very famous one. That also has these kinds of elements. So there is like lots of stuff you can see. Any questions that we have on these topics?
There is a doubt from Jyoti, ma'am, in the chat box.
Yeah.
So I have a question relating to bilateral NDAs. So in that case, if both the parties are sharing confidential information, so why we are calling only one party like a disclosing party and other is receiving? Like how will we determine which one is the disclosing party and other is receiving party?
Yeah, Nishida answered that. Nishida, can you answer?
Okay, so when you call it out in the description of the parties, right, how you use it in the other agreements, similar structure you need to use it here as well. Like a service provider, service recipient, same thing and everything. Disclosing party, then you're going to say that these two people are going to be known as party and party, same. There's no difference as such. When it is bilateral, within the recitals, you're going to say that both the parties are going to share the information mutually. You're going to explicitly call it out in the recitals and make it evident whether it's bilateral or unilateral. If it is going to be unilateral, you will say that the service provider is going to share the following set of informations. If it is bilateral, you're saying disclosing party. Like whoever shares, he becomes a disclosing party. The other party who receives becomes a receiving party. Am I clear?
Yes, ma'am.
Yeah, but you will put the parties as their positions, and you will in a signature or in the description you will not put them as disclosing party.
Both the party will keep interchanging their positions.
Yes, they keep interchanging because it's bilateral. I also give some information. The other person is also giving the information.
So the nomenclature would not be proper. A receiving party and the disclosing party.
No, in the signature it will not be there.
In the signature, that time what happens, you will say the party shall mutually share the following details. That's how it's going to be carved out. But if only one party is going to give, then you're going to say the service provider is going to provide the following confidential information.
If both are giving,
the parties are going to mutually share the information.
Okay.
Then you call out everything. The whole transaction details will be called out.
Okay. So, but the nomenclature be whatever convenience suits us, right? Is it that always be as disclosing party and receiving party?
No, it need not be. It need not be. But this is something that is practiced. But you can use it as you want. As long as there's clarity between both the parties, then that's absolutely fine. The content is more important than the nomenclature.
The recital part.
Yeah.
Thank you.
Okay.
The one on your screen is a unilateral one. This is not a bilateral one.
Can we go with the exercise?
Yeah.
Okay. So are you guys clear with the concept, non-solicit, non-compete, confidentiality? Just put yourself in the position, understand which industry you're working for, understand what would be the threat, then start protecting yourself. I'm sure most of your questions will be answered. But the tips that you need to follow for confidentiality drafting, non-solicit, non-compete, always have it back of your mind. Never miss on them. So all of you are clear on the concept. Can you just say yes, no, something, so that during exercise it's fine. Okay. Komal, you want to explain this?
Yeah. It's so here we are dividing this in two different parts. Okay, so the first one is a transaction of an Indian pharmaceutical company, and they are making tablets, okay, in a specific brand. And now they are looking to associate with a Japanese company to manufacture and distribute that specific brand. So essentially the transaction is what is happening is that the Indian company will give the IP to the Japanese company, and the Japanese company will manufacture it and distribute it in Japan. That's the transaction that is happening. Now, what you have to do in this case is you have to draft a confidentiality clause, naturally, because all the formulation for that drug and everything will be given to the Japanese entity in order to manufacture. And non-compete clause, like, so you are looking at them just to take and manufacture and distribute your medicine and not create their own stuff on that to start selling. Okay, so that is what you have to ensure in this agreement. You have to draft a confidentiality and a non-compete clause, okay, to be included in the licensing agreement. Okay. Supertech gaming, here there is a services agreement with another company where the developer will develop software for this company, okay, and they'll be arranging for secondment of employees. Okay, this is very important. So they'll be arranging secondment of employees to this company for 3 months to develop and test and everything. And now the developer is concerned that the employees who they are seconding to the client will be lured away or taken away by the client. And this often happens, okay. So, like, this is why they are kind of wanting to draft a non-solicit clause, that the client is not going to take away their employees, okay. It prohibits SG from making any offer to the developer's employees, okay, while they are deputed to the client, okay. So often happens, often people lure away service providers, employees, okay. Here now you have to draft a non-disclosure agreement, and here this is an investment transaction basically. So there is this Indian company, and the founder has approached an NRI investor based in Delaware and who's willing to invest in the company. And now term sheet and everything has been signed, but now they are coming to know that the investor is an investor in another competitor company already. Like, they know, they are aware that I will come to the second part of first exercise. First, to understand this, the investor is also investing in a competing entity. Okay, so now these people are really they are not sure, that if we share all of the information and the investor already has a stake in a competing entity, then how does this go? Okay, so can they want to ensure that whatever is happening in the due diligence is kept confidential. Okay, obviously share subscription, shareholders agreements, all those agreements will bear confidentiality clauses. But even before that, like when the due diligence is being conducted, they want to ensure that there is a non-disclosure agreement in place. So that's what you are supposed to draft in this transaction. Okay. Who is still unclear about the second part of the first exercise here? I'll give you an example. It happens in many times in audit firms. Okay. So you will have audit firms because there will be a team of chartered accountants who are deputed for a good period of time to be there on the client's premises and do audit and everything. And if the client finds that this person is sharp and might work very well for my financial department, they'll lure away the employee. And here the developer is really concerned because the client is also a gaming client. So they are thinking that they'll pay more money and lure away my employees, and they don't want that to happen. Is that clear, Chaitali? Yeah. Is everybody clear of the three transactions that are there in this exercise? If you understand the transaction, you will understand the intentions and you will be able to draft it. Who is still unclear? Can someone tell me if someone is unclear of the transactions, the three transactions that are happening here? First is a distribution transaction. Second is a service provision where employees are getting seconded. And the third is an investment transaction where the investor is also invested in a competing entity. Okay. Is this clear, or people are, anyone who's unclear, tell me right now, who's unclear of these transactions?
Please recap, ma'am, once again, the whole exercise, this one.
You want me to recap the whole exercise?
This one, yes, the second one.
Look at the second, it's a very, see, there is a developer, okay, and the developer is a client, which is a gaming company. Gaming company will also need developers at some point of time. Okay, now these people are developing some kind of software for this company, but for that purpose, they are putting employees on deputation to sit there at the client's office and do the work because they need to be there and test the systems and everything. Okay. And now when these guys are sitting there in the client's office, if the client finds that these guys are really good, okay, so the client will give directly them an offer and say, you leave the developer and you join me. And the developer doesn't want that to happen because they have done a lot of headache for hiring people. And you hire people and you depute to the client and the client simply takes good talent away. It doesn't seem good for the developer. So he wants to stop that to happen. So he's going to put a non-solicit agreement in the non-solicit clause in the services agreement that we will second our employees, but you cannot give an offer to any of them. Okay? Does it make sense, Rajiv? Rajiv, is it clear now? Rajiv?
Yes, ma'am. Yes,
clear, ma'am. It's clear.
Brilliant. Okay. Anyone has any gap in understanding what these transactions are now? People are clear? Very good. Okay. Okay, cool. I think we'll end the session now. So thanks, guys. I hope you enjoyed the session. There'll be a feedback form. Is Naresh, would you mind circulating?
Thank you, ma'am.
I think he's left. Or yes, Naresh, would you mind circulating the feedback on form, please? Yeah.
I'm sorry,
Please.
I could not get your question. There was some disturbance.
Would you mind circulating the feedback form, please?
Yeah, circulating. Got it.
It's a request.
I'll circulate. No problem.
Thank you. Thanks
Thank
everybody.
you
But
all.
fill up the feedback form. Huh? Fill up the feedback form. Very important.
Yeah.
Thank you.
Komal,
Good night.
I just
Yeah.
wanted to ask one thing.
Yeah.
Yeah, regarding assignments, I wanted to send the mail. So, to whom shall I send the mail?
support@lawsikho.com, cc yash@lawsikho.in. Want me to put that in the chat?
Kindly do that.
Yeah.
Rajesh, CC it to me as well because I'll be evaluating.
CC Pallavi.
Sure.
support@lawsikho.com, yash@lawsikho.in. Pallavi has already put her ID. Okay. Pallavi@lawsikho.in. These 3 email IDs. Okay. Support is .com. The other 2 individual IDs are .in. Okay.
Komal ma'am, I want to change my monthly article, the article assignment. I have messaged there in the group, but I didn't get any response.
Same method.
All right. So I have to write at all these email addresses. Okay. All right. Thank you.
See, there is a ticketing system there which resolves these. Okay.
Okay. All right.
Okay. Thanks, guys. Good night.
Thank you all. Good night.
ma'am. Thank you.
Bye, Komal. Bye, Pallavi.
Thank you, Nishwita ma'am. Thank you.
Bye-bye.
Thank you, Pallavi.
Thanks, Komal.